Perfect. And we'll give everyone a minute to get in. Hello to everyone. I want to say hello first and welcome to our Argent Bridge Coffee and Conversation. And we're going to start in a minute, but there's a lot of participants entering the room, the Zoom room. So I'm going to give us a minute here, if you don't mind, while we let everybody get logged in. Wow, we have a bunch of participants. So Jennifer, this must be a very hot topic.
Exciting for a late day Thursday appointment.
Yep. Probably even too late for most of us for coffee, even though it's coffee and conversation. I won't sleep tonight. Okay, we're getting there. While everyone continues to file into the room, I want to thank you, Jennifer, for joining us and let everyone know that Jennifer Schiffer is an estate attorney, business attorney at Bean, Kinney and Corman. She's a friend of our practice. She's actually done our coffee and conversations before on the topic of estate planning, and I want you to know how much we appreciate that. And thank everybody for joining. You know, we were focused on estate planning a little while back when we thought there were going to be some major estate tax law changes, and when that didn't happen, it didn't take away a lot of the questions that people had about bigger topics and some of the things that I think that we're going to cover today, Jennifer. So if it's okay with you, we'll get started. I've made a few notes and I know that you did too. And I want to, again, thank everybody and maybe just get started with a basic, like your view, Jennifer, of a well-designed estate plan, something that you think everybody here should know or give some thought to if they're going to go down the path of starting or amending a plan.
Sure, absolutely. And thank you so much for having me. I always look forward to working with you guys and talking with you and your clients. So, you know, a well-designed estate plan, I get asked that question a lot, and I get people coming to me saying, I don't have anything. What if I just go to LegalZoom? So my short answer to the question is anything is better than nothing, but a well-designed estate plan is going to be done with an attorney or with someone who's familiar with the state laws of where you live, because among the 50 states, the laws differ, you know, on different things. So an estate plan should consist of at least a will, a power of attorney, and an advance medical directive. Those sort of give you a baseline of things to do. A trust oftentimes is something I'll throw in and tell you you probably should have. Diane likely will tell you should throw in and have. But again, sometimes a trust scares my clients away. And they're like, well, I just can't do anything. And I say, no. Let's at least get the will, power of attorney, and advance directive down. And then you can always come back in a few years and come up with a trust if you need to.
Thank you. I appreciate that. Yeah. And then again, another basic, and I promise we'll get into some things that I think are more advanced topics that we get questions about, but how often should we be reviewing? That's good for us to know too, in terms of bringing it up in our own financial planning meetings. How often should we be reviewing the estate documents?
So the rule of thumb is every 5 years, or in the event of a major life circumstance change. And what we mean by that is, you know, if your children go from being 16 to 21, that's a significant life change because they're now adults. And if your estate plan or your beneficiaries or things are not correct, they could potentially inherit everything. Similarly, if you inherit a large estate for yourself and your wealth changes, that's sort of what we mean in those large life events. Ironically, going from one child to 2 children isn't necessarily a major life change for estate planning documents, because often for my younger families, we build in the fact that they potentially are going to have more children. So that is a major life circumstance change to you, but not necessarily for estate planning purposes if your documents are done correctly.
I have one more question about that, but before I forget to tell everyone, at the bottom of the screen and possibly at the top of your screen, there is a double bubble that says Q&A. I want you to feel free to ask questions, and we'll try to make sure we get to any questions that folks have. Again, my questions for Jennifer are questions that have come up in financial planning meetings. So I hope that if some of these are yours, we're going to do a good job of covering those. And I know, I don't want to backtrack, Jennifer, but I do know that you talked with Cecile at length, and we have on our website that webinar that you did with Cecile on estate planning. But is a like a change in circumstance, could it also be if there's some sort of a medical condition, or is there a time we need to be thinking about whether someone's capable of serving, or is that, does that create a whole series?
Absolutely. I
we
mean,
need to think
definitely a
about?
major medical event. You should look back and make sure your documents say what you want them to say, because quite frankly, you don't know what the future is going to hold for you. And yes, capacity is a huge concern that we see time and time again. Questions about, someone says, well, my aunt executed power of attorney 10 years ago, giving it to my uncle, but uncle is now deceased and aunt's capacity is questionable. So we analyze with you potentially whether she has the capacity to sign a power of attorney or a will, because the mental capacity to execute those documents sometimes might be lower than you think, but it's a quick action item because that mental capacity can drop off like a rock.
So as soon as maybe as soon as there's some sensitivity or awareness of a situation, it's time to revisit.
Correct. I think so. And similarly, probably for you all, just look back at your insurance and make sure whatever your life insurance, long-term care insurance, that you have it and you understand what it is. And,
Well, that brings me to my first, I think, of deeper dive questions. And that is, there are often times when we may meet maybe a new client and they come in with a stack of estate documents that they have no idea whether or not they'll ever execute. So I wanted to get your thoughts on that. Maybe things like a residence trust or a dynasty trust. At what point are these necessary? Do you see them successfully executed? And in what scenario might a client think they need to at least talk to an estate attorney about some sort of more sophisticated or advanced estate planning tools?
Absolutely. So that's a good question. And quite frankly, I'm working with a client right now who had been to an estate planning attorney probably 15 years ago. And they came to me with that stack you're talking about, which was including a will, power of attorney, advance directive, plus a revocable trust. But then it included a dynasty trust. And they're like, we don't know what this is. I was like, okay, let's backtrack and figure out how your assets are owned, because then we can figure out whether it's even worthwhile or not. So the revocable trust, in comparison to these more complicated trusts, is a fairly simple trust that's no different than you while you are alive, because you are the grantor and you are the trustee. And indeed, it uses your social security number. What it does for you is it enables you to pull your assets so that you don't have to go through probate, and can create various strings. For example, if you have young children, you can say the trustee will babysit the money until they reach 35 and can use it in the meantime for health, welfare, education, things like that. So that's a fairly basic trust that just accomplishes your particular goals, but isn't giving you more beyond that. So the residence trust, the dynasty trust, things like that are going beyond that and are more tax planning tools and help, among other things. But first of all, for tax planning, in Virginia, we're lucky that we don't have an estate tax at the state level. In this area, Maryland and DC do. So we sometimes use those trusts to help get around the Maryland and DC estate taxes, because DC is at 4 million and Maryland is at 5 million. The federal estate tax is at 12 million. So that's a large gap, right? And so some of these trusts help us deal with that issue. The other thing, a dynasty trust particularly, and in this client's instance, they were concerned about the mental state of one of their children. They're not special needs, but they're sort of not the best with money. So the dynasty trust was going to help them continue on their legacy, let it skip down, do some tax planning, and get it over and past that child. Well, where sort of the errors came in from what had happened with this old attorney to where they came now 15 years later, all of their assets, they had moved into their revocable trust. Their revocable trust had no mention of the dynasty trust whatsoever. And I was like,
Wow.
well, your dynasty trust is essentially as valuable as the piece of paper it's written on, because it doesn't, these goals are great. And I said, so you all need to figure out, we're 15 years later, your child's mental capacity has changed, to figure out now, are you really looking to skip her and let it go down to her children and her children's children and so on and so forth? Or do you want to keep it how we have it now? But that dynasty trust, so that's where those come in. Similarly, residency trusts, particularly again in DC, we use residence trusts a lot to put a primary residence in, let it grow, and so it's pulled out of that $4 million estate tax that DC hits you with.
Wow.
So the complicated trusts definitely have their place and make sense. But yes, those clients that come in with those huge stacks of documents, I mean, their initial comment to me was, well, let's just revoke all of our trusts and get rid of this whole trust structure. I was like, no, I don't think that's what you mean either. But that's why I say when we first start off, trust sometimes scare people away
Right.
from doing anything.
Sometimes I think the complexity maybe, again, solved a problem, but didn't necessarily give anyone the comfort that they needed to know that things were going to happen in an order they hoped they would happen. That's a great example of it. So you're saying, if you have a revocable living trust and everything's there, if you created something irrevocable and it's not mentioned and it's not funded with anything, then it's moot.
Correct. And in that instance, that's where it's sort of overkill. Now, the dynasty trust was a great idea and did the right things
Would have
and
solved
accomplished
for,
their
yeah.
goals, but it had nothing in it. And so that's where we sometimes have to be careful, both with revocable trusts and all these more complex trusts, is if you don't fund the trust ever, it's useless to everyone.
That's right. Yeah, that's another thing that we see often, that someone's done a really thoughtful estate plan, but never put any of their accounts in the name of their trust or funded their trust. Sometimes they don't even understand what funding the trust means. So yeah, I can appreciate that. We have several questions coming in. So and a couple of comments. Maybe I'll start with this question, Jennifer. And if it's something, if there's another, there's a couple that are similar to a question I'm going to ask, so I'll save. This one is, are A/B trusts still an efficient strategy, or is there a newer, better version?
So the short answer is yes, A/B trusts are great. But what I would say, they're great DC and Maryland if you're at that estate tax level, so that you can inherit each other's. Now in DC, they actually did away with your ability to inherit each other's estate tax exemption. So each of you gets 4 million, but that's it. And if one of you dies and hasn't used your 4 million, it's gone. The A/B trust for the federal purposes is great, because then it sets up you inheriting each other's 12 million. But quite frankly, it's portable, meaning you automatically inherit it as long as you file an estate tax return. So A/B trusts are fine and good in certain circumstances, but not necessarily necessary. So it depends on your specific situation. And certainly you can go to the internet and download an A/B trust, but they're kind of going to differ from state to state potentially.
Thank you. And the next one is actually a caution from a personal experience, but also a great reminder. And that is, this says, I only had a copy of my father's will, not an original. Fairfax County would not accept my copy and declared Dad had died intestate. Fortunately, this was not a problem because Mother had died previously and I'm an only child. So get an original will, and I'd guess also originals of the living trust, healthcare powers, etc. That's a really great point.
Absolutely.
Originals.
We say keep your originals in a safe place, but not a safety deposit box, because someone would need the original in order to access the safety deposit box. In this day and age, it's fairly easy to get a copy of a will admitted to probate with the attestation of the witnesses, if you can get it, but keeping the original would be the best thing.
Super, yeah. And then another that says, when you live in two states, how do you decide which state? And actually, I had a whole thing on residency, which we'll still get to, but I'm curious, when you live in two states, is it the state in which you claim as your state of residence? Is that where you file the will? Or?
So file the will as in after death and deciding which state you go to probate in, or file the will as in giving it to the county court to hold. Generally speaking, I say I wouldn't give my will to the county court because if you see their records, they're a mess. You're likely better to keep better copies yourself, and you can tell someone where your important papers are. At death, deciding which state, there are a whole different bunch of laws, and particularly it surrounds if you move to a state simply for purposes of receiving nursing home care. Are you actually resident there or not? Did you establish your residency there? The first test is, where did you sleep the majority of the past 180 days prior to death? But then we get into all sorts of different things because the law hasn't necessarily evolved, because some of them are, do you have a driver's license from that state? Did you open a bank account in that state? No, all these mega banks are all in every state, so no one's opening a new bank account in a new state. So sometimes it's filing, where did you file your income tax returns? Where did you register your car? But so we get into lots of those issues, and that's where an attorney can definitely help you. And I can tell you, one of my clients, I just had this residency question. She had moved to assisted living, not just nursing home, but assisted living many, many, many years ago prior to her death. She still owned her residency in DC, but she stopped filing it as DC resident taxes, again, many, many years ago. And ultimately, when she died, we decided, well, hey, you're a Virginia resident because you were filing income tax returns in Virginia for the past several years. You didn't open a bank account or anything, but that helped save a lot in estate tax because she's under the 12 million, but over the 4 million. So, sometimes it's just a matter of consulting with a professional who can help you make the right decision.
Thank you. And I had a series of questions that came up in various means. I'm going to just make sure I cover them. So the issue of residency, especially, is there anything relating differently to trusts in residency or estates in residency? A couple of them, like, does it matter where the grantor of a trust is? Or my very question of, what if they have dual residency? Is that any different than, say, someone who creates a will, and the will, whether it's Virginia, Maryland, or someone who has a trust, is it Virginia, Maryland? Does it matter? Is it relevant? And so, what about trustees? Like, when, say, a client is here in Virginia and create their trust with you, and their son is in Florida, and the son is the successor. Mom is now not capable of handling things. Successor son steps in, but he's in another state. Is any of that something to consider now before it becomes an issue?
So yes, absolutely. I mean, one of the things we talk about is, if you change what state you are a resident of, definitely look back at your trust, because potentially, let's say you moved to Virginia from California and created a California trust, and your trust says California law applies, the situs of the trust shall be California. Well, you're now a Virginia resident, but your trust says it's California. We potentially want to change that because California will want you to fulfill their requirements. And I don't necessarily know. I know they're burdensome, whatever they may be. So that's the time to think about changing it. In general, where the trustee resides doesn't matter. Where the successor trustee doesn't matter for purposes of the situs of the trust. Where the initial trustee is potentially does, because, again, it's declaring what state that trust is a resident of. And that means, so while you're alive, a revocable trust, again, is no different than you are. An irrevocable trust, those more complex residence trust, dynasty trust things, those are paying taxes from the moment assets go into them. So it partially is, what state is your trust a resident of to pay taxes to? And so we've been creating a lot of those more complex irrevocable trusts as Delaware trusts or South Dakota. because those are the two main places that have updated their trust laws. You're avoiding paying taxes now potentially to the states. But so realistically, you as a Virginia resident could have a revocable trust that's a Virginia trust and an irrevocable trust that's a South Dakota trust. And you've declared it in the document. But that's where when you move around, you definitely want to make sure you sort of are updating that. As for the dual residency, I'm actually working through these issues right now with a gentleman. I would say he literally lives in DC 6 months of the year and Maryland 6 months of the year. And he's like, well, what do I do? Where am I picking? I said, well, ultimately, what are you doing for purposes of your taxes? He said, well, I have to file taxes in both. And I said, well, then I think for purposes of your trust, we can pick a state and you go with it. And I said, ultimately, this is one of those every 5 years or in the event of major life circumstance change, look back and update it. I don't think forevermore that's going to continue to be his lifestyle. And there are lots of people who are 6 months a year, Florida, 6 months a year, New York, but they do pick a state. And so that's just sort of, again, talking to a professional, having a discussion about what makes sense for you. And if you really truly are a dual resident, let's pick the one that's most tax efficient for you.
Excellent. Yeah. In that case, did you use Maryland because you could drive a little bit more? Okay. Yeah.
Yeah, we did Maryland for him. And then one of your other questions you asked was the beneficiary.
Yeah, I was just going to get there. Yeah.
Of the beneficiary, that doesn't change necessarily the overall trust that you're a beneficiary of, but what you're receiving out of the trust. And potentially, where we have trusts created, grandpa and grandma created a trust, son is an income beneficiary, but son's children are actually the beneficiaries ultimately. And he became the trustee over the children's trust once grandma and grandpa died. That does get into that beneficiary, what state they're potentially in. And yes, if they're in another country, that beneficiary, there are lots of different issues that we need to deal with because, for example, the gift tax differs, the income tax differs, and that's where we'd like to see in the trust the ability of the beneficiary to disclaim or decant so that it's not coming to them and it's not based on where they reside, but somewhere else.
So that's handled through like the ability to disclaim?
Potentially. I mean, disclaiming is saying, I don't want those assets. It goes to the next generation. And that's where if it's grandma and grandpa to son and then son to his children, he may say, just leave me out of this. It all goes to my children. But, when you're in a foreign country, we say you have to check with a local attorney there because from experience with clients, France just digs their hands into everything. And sort of, it seems from what I've learned, 40% just off the bat is taxed. Right. And so that's where I wish my clients had consulted with a French attorney because there were ways around it that they didn't know.
Well, we have something similar now in that we have a beneficiary who's going to be permanently living in Canada, and the grandparents are concerned what will happen when we try to leave money to the grandson who's no longer in the country and not coming back. And so do the grandparents who are leaving the beneficiary money need to think about that, or does the grandson who will be the recipient, or both?
I mean, both potentially, but ultimately the beneficiary is the one who really needs to think about it because, some of my clients who are in grandma and grandpa's situation say, I'm dead at that point. I don't care. Figure it out.
They care. Right. Yeah.
That's not the best estate planning tool, but, they may just say that's way above my pay grade. Leave it to you down the line.
And where there are circumstances where money is sent overseas to care for people, we have a scenario similar to that as well, where the estate planning document is going to include something that remains, say, a trust here or a partnership here that remains in the States so that the responsible party can continue to care for someone overseas. And that came from Bean, Kinney and Corman. So thank you. I think that's that's a great use of estate planning tools when that it's likely that this person's going to need financial support for a long time, and yet you may not be around to be the provider.
Exactly. And that's a great use for a trust, and a more complex trust than just the basic revocable trust.
Right. Great planning. Speaking of beneficiaries, I think I touched on this with you because a mutual friend of ours is doing some estate planning, and this issue about what if spouse predeceases husband or husband predeceases wife, and each of them have their own, so no children, they have their own charitable bequests, and they're not the same. How do we plan around beneficiaries to ensure, in other words, husband dies first and wife gets his whole IRA, and wife has her own beneficiaries and his are basically wiped out. And or the other way around, wife predeceases and hers get wiped out, because we follow the IRA owner's beneficiary guidance on their account. So if there's no more IRA because husband's gone, we will follow, and all assets are in wife's, we will follow the beneficiary designation there. So how can we help clients ensure that wherever they'd like to see whatever resources are left, how do we ensure that it gets to the right beneficiary?
So there are a bunch of different ways. I mean, the simplest is a life estate inside a trust, meaning there's a trustee who holds the money in that trust and distributes to spouse the income off of the assets, and potentially even as much principal as necessary to that spouse. Then that life estate terminates at death or some other event such as marriage in that trust. And then within that trust, it then says where the ultimate beneficiary goes.
Okay.
So that's the simplest way of doing it. But there are many other ways. I mean, people say, oh, I trust my spouse. I'll leave my whole IRA to my spouse, and then my spouse can go and update their beneficiary so that 50% goes to A, B, C, and D, and 50% to E, F, and G. You know, I mean, that's not legally binding, but that's certainly a way of doing it. But then there are other types of trusts that can do it. You know, there are charitable remainder trusts where there's income being generated off of the funds in the trust that you could designate the income continue to go to spouse, and then ultimately
Yes, yeah, of course.
assets go out. And so there are different ways. You know, I have a client right now. He has a family limited liability company and a family limited partnership. He's married. He has a second wife now that he's married to. And he said, I want wife to be able to receive my income, but she's like, I don't want her to have any control over this family LLC at all. It ultimately will fall to my children. But, you know, brother and dad are in control. Brother and dad can make all the management decisions, but wife gets the income. Wife can't touch any principal. Wife has no voting rights. But this way, he at least is giving her something. She has some stake in the business ongoing and is taken care of in the event something happens to him. Now, his, interestingly, cuts off once his children hit a certain age. They then step in and take over his interest, and the income wouldn't even go to the spouse, which is where it's a more
Interesting.
complex trust.
I had a question for you about donor advised funds versus charitable trusts, but I think I just answered, well, I want to ask it so that you can answer it for everyone, but in a donor advised fund versus a charitable remainder trust, in both cases, the objective is to get money to charities. In the donor advised fund, it's happening immediately. Often we use highly appreciated stock to fund that charitable account. And then, you know, the owner of that charitable account disperses to their charities as they see fit. And that works great. But a charitable remainder trust would leave an income source to someone, where the donor advised fund, that's done. That's a completed charitable gift, right?
Exactly.
So
Correct.
that kind of, that's, okay. Well, and maybe you want to expand on that, because maybe the charitable remainder trust, is a better fit when there are residual income considerations.
So yes, I mean, potentially a charitable remainder trust is a better fit, or multiple different types of trusts. Where I have clients that struggle is they have charitable intentions, but like they're not willing to do the donor advised fund now, simply because they're not willing to part way with the money now.
Right. Well, and sometimes they don't know if they're going to need it for their own well-being, right? That's
Exactly.
the limitation.
So, in general, a donor advised fund for everyone is a fund where you go and create a separate account essentially, and there's a donor managing it, and you potentially are the donor, designating to what charities this money is getting divvied out over a lifetime. It's a great way, as Diane mentioned, to not have to pay capital gains on highly appreciated assets. That was a huge problem 3-4 months ago. We're in a different market climate now, so that people may not be having that same problem. But the donor advised fund is a really great way to protect at least some wealth and get it to charity. It doesn't have to be now, it can be over time, but you're making the charitable contribution today and then deciding over your life what charities get this, versus the charitable remainder trust. You're putting assets in there, but they're going to continue to grow and have income and things like that that'll come to you during your life and then go away and distribute out. And it doesn't even have to be a one fell swoop charitable donation at your death. It can be a staggered, I'm going to donate 10% over the next 10 years to the University of Michigan. And that's what it can be. So there are lots of different ways, but particularly the charitable remainder trust is a good way potentially if you want to help protect your spouse, but protect your wishes. And the life estate is sort of the same idea. If you want to help protect your spouse with income, but have your own wishes control.
Awesome. Excellent. One quick housekeeping. Somebody said they missed the first few minutes of the call, and will there be a recording? Whether it's sent out, I don't know. I know it'll show up on our Argent Bridge website, but I'll have Elise circle back with everybody when she's back from vacation about that. And then another, sorry, let me see. No, looks like that's a prior one.
So, one thing sort of related to trusts is I know as elderly parents are dying, and quite frankly, we're sort of going through it in my own family, is okay, grandma created a trust for us. What does that mean? How are we as the beneficiaries? What do we have to do? I have one client right now. He's absolutely paralyzed. He says, I don't want to sell anything. I need to get everything out. And so the trustee's responsibility is to gather the assets, make sure, the assets are not being spent in frivolous manners. I don't mean by the stock market crashing, which was his main concern, because that is what it is. But I mean, don't go and ship it off in a bottle somewhere and expect it to come back. And so the trustee really needs to be gathering all of the assets, figuring out what they're going to do to make the wishes of the grantor fulfilled. And if it's a certain percentage, okay, they may need to wait and make sure all medical expenses, taxes, things like that are paid. And then we can start making distributions. And as a trustee can make partial distributions over time. Some trusts are written to have it immediately grantor's death distributed, but that doesn't actually mean the moment grantor dies, it's all going out. It's going to be a process. If there's a home owned in the trust, the home needs to be probably updated in order to be sold. Taxes probably need to be paid on the home, and then ultimately the home sold, right? So the trustee may sit there a little bit of time. So we get asked, what's a reasonable period of time? When does a fiduciary sort of breach their fiduciary obligations? I would say it's certainly not a snap of the fingers. Generally, our rule of thumb is a year, is we like to see some movement going on in trusts within a year of death, unless there's some extraneous circumstance, either on the beneficiary side or on the grantor trustee side. If some trustee knows that some beneficiary has a massive tax judgment and they're just holding out on distributing anything, for that, that may be an issue where it could be a breach
Yeah.
of fiduciary obligation. But generally we say a year, give it time. Because a lot of people, it's an emotional process. You have to get through the emotion of the person leaving to then deal with their financial assets.
Great guidance. I have one question that came up on about irrevocable trusts in general. This happened to be an irrevocable life insurance trust that clients set up. It was funded with life insurance, second to die of the husband and the wife who are now divorced. Are you there, Jennifer?
Okay, sorry.
That's okay. You froze for just a minute. So
Don't know what happened.
okay, it's just the question is an irrevocable trust that's set up, funded by second to die life insurance that was earmarked for a child who early on they were concerned was going to have some disabilities that the child has disabilities and they were concerned they weren't going to be self-sufficient. It turns out they are. And it's less of a concern. He's employed and he's living independently. Can an irrevocable trust be revoked? I mean, and what do you do in a situation such as that?
So, I mean, short answer, no.
Right.
But longer answer is the trustee may have great discretion as to when distributions out of that trust can be made. For example, our special needs trusts that we write in circumstances like that, it has lots of trustee may and trust as opposed to trustee shall hold the assets and trustee.
Okay,
will
so
only
more
distribute.
flexibility maybe.
Correct. And that's where it really is going to depend on the terms of that trust and the trustee's discretion. I mean, and certainly if the child is competent and can manage money themselves, the trustee potentially can get waivers and things like that, which are sort of a circle way around where the irrevocable trust can't be revoked. But if the trustee and the beneficiary are all agreeing to going outside of it, well, you kind of have revoked it without really revoking it.
Okay. Yeah, that makes good sense. Yeah. And again, one of those situations where early on best of intent and then unnecessary and you've got something that's in place. So I guess it speaks to what you said at the very beginning about, all of the possible estate planning tools. It's what are you trying to solve for? And even when you get that right, I think sometimes it's circumstances change. And so we've got to be really careful about what we make that's irrevocable, right?
Correct. Absolutely. And one of the things with irrevocable trusts, just because you create it today, you can put some assets in today, you can put some assets in tomorrow, some assets in a year, but at least you sort of have the framework and are starting to think about it is one thing I encourage people to think about.
Oh, that's excellent. So it doesn't get overdone. Correct.
Because I have one client, she's come back and forth with me multiple times trying to do an irrevocable trust. And it's like, I can't, she keeps thinking she wants to put her $10 million piece of property in there. And I said, let's do it in baby steps. Let's not go with 10 million right now.
That's really smart. Well, I mean, here we are, it's 40 minutes already. So I got to tell you, Jennifer, what you do is so valuable. I appreciate everything you're doing for our clients and for us, and that you're always such a helpful resource when it comes to our estate planning questions. So I thank you for that. I thank everyone who asked questions and hope we covered questions on a more sophisticated level. There's certainly a lot to this, and we're going to keep the conversation going.
Absolutely. And I would say, we always tell Diane and everybody at Arch and Bridge, don't hesitate to reach out. No question it's dumb, because just like I ask her questions that I don't know, that's why we hire professionals, and you all have your own professions, and that's why we all have different specialties.
Thank you. We very much appreciate everyone joining us today too. It's such a nice collection of questions and our everyone who was able to participate. We appreciate it. For those that didn't catch the whole thing, I'm certain there'll be a recording, and it'll be probably within a week on our website. So thanks again. And Jennifer, thank you. Appreciate it.
Thank you, guys.